So in this video, I am going to discuss patents according to Amazon sellers and e-commerce sellers. What do you do if somebody is violating your patent if you own one? And then also, how do you navigate patents when you are creating products? And also if you get in trouble for a patent violation or you get like a letter or something like that, what do you do to deal with those things? First of all, I want to give a quick disclaimer. I am not an attorney. This is not legal advice. You should definitely consult an attorney if you are dealing with anything like that. But I will give you my kind of CEO level experience with patents. I have actually been through patent litigation, and I know what this is like from an e-commerce owner, brand owner's perspective, and how to deal with it. I've also worked with several customers that we do consulting with that have dealt with patent issues as well. So this is my advice from a business owner to business owner type perspective. So the first thing that I want to explain really quickly is how to do patent searches. And when you're developing a product, what do you need to do that? So you can do your own quick patent search just using USPTO or Google Patent Search and just type in brand names, keywords, and all kinds of things there to start trying to find patents for your competitors. You can also look at their product packaging. You can buy it. You can see if they have patent numbers written on there. You can look at their websites. You can do all those types of things. If you want to be very sure that you're not violating any patents in any new product development, it would very much behoove you to hire a patent search company to have them actually do a patent search for you and an evaluation. You can also hire a patent attorney as well to do patent searches and basically evaluate your product to make sure that you're not violating any type of patents that do exist. Most of the time, if you're a small Amazon seller, and you're just doing like a little small product, you can probably avoid the high cost of hiring a patent attorney or doing patent searches and just do your own little bit of research. If you only order a few hundred or even 1,000 units of something, you're probably going to be able to sell a lot of that before the guys even, if there is a patent that you might be maybe violating, you're probably going to be able to sell most of that before you get slammed with a letter. But if you're spending a lot of money on something, you're developing like this brand new technology or whatever, I would definitely consider doing some patent searches up front. And likely you're going to be working with an engineer as well. And so that engineer will be able to work with you and look at the patents, and you can kind of make sure that you're not violating anything. Okay, so I want to talk about the two different types of patents that we have in America. We have design patents and utility patents. Okay, so a design patent is much easier, cheaper, and faster to get. They're going to cost, usually we've paid between like $2,000 and $4,000 for just the actual getting the lawyer to file the patent and getting the patent ready and everything. So fairly easy. And I think we got our patent in like 6 to 12, I think it was like 12 months or so when we got our patent from the time we applied for it. And so those are fairly easy to get. They don't offer you as much protection in the way of being able to sue somebody because they're fairly easy to get around. Basically, the judge of a design patent is if a consumer could not tell the difference between your product and the design patent's product, right? If they can't actually tell the difference, then they're probably going to lose a design patent litigation case. A utility patent actually is the function or the utility of the product. So the products could look different, but they have some sort of mechanism in there that is unique to that patent that gives that product this, patentable qualities, right? And so the thing is that utility patents are very, very specific. You can't just have a very broad patent because that would be abuse of the law and using the government to kind of control everything, whereas patents are meant to be to reward like inventors and innovators to give them a little bit of protection for the effort that they spent developing their products. So the idea is that the patent has to be very specific, and usually to get a patent you have to be very, very specific, and so a lot of times people can engineer around your patent. So if there's a product that you want to make and they have a patent, don't just assume that you can't make that product. You just have to spend the extra money in an engineer and a lawyer to make sure that you are making something that is not violating their claims. So typically, a patent has to show what's called prior art. So these are all the inventions that have come before that patent's built upon, and then they have to explain how they've added something new and innovative into the product and things like that. And so if you kind of look and you read their patent, and I'm not an engineer, so I can't tell you exactly how to do this, but basically if you read their patent, and they'll basically make these specific claims about how they have developed this product, And then if you can find another way to get the same type of product, but you're not using the exact way they did it, then you can make a product that is not violating their patent. And so it's fairly easy to, if you really want to get around patents and things like that. If you have the right engineering and attorneys and things like that, you can still go against products that have patents. But if you want to be really safe or you don't have a bunch of money, then you would just avoid any type of niche or area where there's a brand or a company or companies that have all kinds of patents and everything. Now, traditionally, patent litigation is very expensive, especially utility patent litigation. You can spend easily hundreds of thousands or millions of dollars in patent litigation. And so there's kind of two sides of that coin. Most people, if you're going up against like a normal, not super well-funded brand, and they might have a patent, they're probably not going to want to take you all the way through patent litigation because that's going to be really expensive. On the other hand, if you are developing a product and you have a really big name brand and you're not dang sure that your patent doesn't violate their patent, then you better be careful against going up against them because they have the lawyers, the attorneys, and everything to basically sue you into oblivion and make you have to spend a bunch of money in court. So choose wisely when you're doing some stuff. So what do you do if somebody is violating your patent? You have a utility patent and maybe there's a Chinese company that's knocking your product off or whatnot. Like, how do you deal with that? Well, as we know, patent litigation is very expensive and it can cost you a lot of money. But Amazon has something that's pretty nice that you can use. It's called the Amazon patent neutral evaluation, or maybe I'm getting those words mixed up, but something like that. So basically what happens is it costs $4,000 to go into this patent neutral evaluation, and you put up the money, and then you basically say, look, this company, this listing is violating my IP, and then the competing company has to put up their money as well. So they have to put up the $4,000 as well. If they don't put up the money, they're automatically kicked off. So the first thing you do is you get your lawyer to do the patent neutral evaluation, and then you put up your money, and then Amazon, the competitor, has to put up their money too. Then you have time to make your claims and submit all your stuff, and then the other company has like a couple of weeks or a very short amount of time to respond to the claims and everything that you're making. And then a lawyer basically will evaluate that. A patent attorney will evaluate it. So it doesn't have to go to a judge or a jury trial or anything like that. It's this very short process where they will just deal with it internally, basically, on Amazon. If you win, then you get your money back, and the competitor or the person that you were suing or taking to arbitration, basically, they lose their money. And if you lose, then you lose your money and they get their money back. So it's a fairly good way that if you're pretty confident that your IP is being violated and you think a patent attorney is going to agree with you, it's a fairly good way to get somebody to court quickly. And if they don't really have a case, they probably will just go away and they won't actually do it. And then if they do have a case or if they think they can win, well, at least you're able to kind of solve this without spending hundreds of thousands of dollars trying to get somebody in court and things like that. Now, here's the thing. You can still take them to court after the patent neutral evaluation. So if it doesn't go your way and you're not happy, it's not like you're waiving your right to actually having a jury trial or anything. It's just a way to kind of quickly deal with this stuff internally without having to take it all the way to court. Now, what about if you are on the receiving end of something? Let's say that you are selling a product and all of a sudden you get a cease and desist letter from a company saying that, hey, you're violating our patents and everything. So I would say, first and foremost, this is when you do need to hire a patent attorney and have them do an evaluation on your product. Typically, they got to give you some time to respond to this letter. They're not just going to, start suing you right away. It's very expensive to do it. So I would just keep on doing business as normal and then take that letter that you got and immediately give that to your attorney and have them do an evaluation and be like, am I really violating this patent? Like, do I have a case? And then basically, it's going to cost you a few $1,000s to get that case figured out, to get the attorney to look over that case. And they're going to tell you how much liability you have, how big of a risk is it, what's the likelihood of you winning. Like, oh yes, you're definitely violating this patent, you should quit selling it, or actually we think you have a really strong case. And then you can decide what you want to do from there. Do you want to be aggressive and try to fight this thing? Is there enough money in it for you? Or is this a product that you're just, going to sell out of and stop selling or something like that? And that's kind of your decision on what you need to do. And you should definitely counsel with your attorney on what strategies you should take in that way. A couple other things that I will mention is that if you are dealing with people violating your patents specifically, I would definitely recommend going after the little guys first, suing them, doing patent neutral evaluation, doing as much as you can to build up a history, because whenever you do go to court, it looks good if you have wins under your patent. A lot of patents are crap, honestly. They get pushed through the patent office and you have a patent technically, but it's not really enforceable, right? And so what you need to do is a patent that's actually been to battle, been to war, and won litigation is much more valuable and much more easier to enforce than some patent that is never been tested in a court of law or anything like that. So if you do see somebody violating your patent and you're confident they are, then you should take care of them quickly and try to kind of go after them as fast as possible. Whereas if you wait a long time and they get a bunch of money and they're able to defend themselves and stuff like that, you're going to have a lot harder time dealing with them. So that's kind of both sides of the equation here. If you're a seller, I definitely highly recommend looking at the patents and making sure that you're not violating stuff. If you can, hire a patent attorney if you can afford it, to make sure that you're not violating anything. If you are a big brand or you have your own patents or things like that, then I would recommend being aggressive in enforcing your patents. If that's a part of your strategy, then don't wait to let your competition get really strong. You should attack them quickly. So there's a lot of other things I could talk about patents. If you guys comment and subscribe and let me know if you like this type of content, I could do a whole series on patents and things like that. Just let me know questions in the comments. I'd be glad to help you out. I would like to end on saying, don't freak out if you are a small person and you're really worried about patents. It's usually not an issue until you get bigger. So don't let this discourage you from starting your business. But if there's any content that you guys want to hear about patents, let me know in the comments below and I'll make more videos on that. Thanks again for watching, and please subscribe to the channel.